Just before we do get started, can I just remind you all to also put off your phones. Good morning. I welcome members to the 30th meeting in 2013 of the Delegated-Powers and Law Reform Committee, and ask them to switch off their mobile phones and any other electronic devices. Apologies have been received from Nigel Don, and I welcome Bruce Crawford, who I understand is attending as his substitute. I'm going to move on to agenda item number 1. This is the consideration of a draft document subject to approval. No points have been raised by legal advisers on the Model Code of Conduct for members of devolved public bodies draft SG 2013-250. Is the committee content with this document? Okay, thank you. Agenda item number 2 is the draft document subject to Rule 10.5 of the Standing Orders. This is the consideration of a draft document subject to 10.5 of Standing Orders. No points have been raised by legal advisers on the Land Reform Scotland Act 2013, Modification Order 2013. Land Reform Scotland Act 2003, Modification Order 2013, the Statutory Guidance SG 2013-254. Is the committee content with this document? Okay. Agenda item number 3 is consideration of draft instruments not subject to any parliamentary procedure. Some points have been raised by legal advisers on the Public Services Reform Prison Visiting Committee's Scotland Order 2014 draft SG 2013-219. In particular, the meaning of prison records, where that term is used in Articles 2, subsection 2 and 3, inserting new sections 7, subsection 5 and 7A, subsection 6 and 7B, subsection 5 of the Prisons Scotland Act 1989 could be made clearer by defining the term, and that those provisions confer functions on the Chief Inspector of Prisons, prison monitors and lay monitors in relation to the inspection of prison records. It is not clear whether the term covers records located both within and outside of prisons, nor whether the meaning intended is the same, irrespective of the person who exercises the functions of inspecting records. And the meaning of prison records, as the term applies for the purposes of remand centres and young offenders institutions, by virtue of Article 2(7), could also be made clearer. The Scottish Government has undertaken to consider this lack of clarity before the order is finally laid before Parliament for approval. And does the committee agree to draw the draft order to the attention of the Parliament on reporting ground H, as its meaning could be clearer? And does the committee also agree to note that the Scottish Government has undertaken to consider this matter before the order is finally laid before Parliament for approval? Yeah. The instrument also contains some drafting errors. First, Article 3(2)(c) amends Schedule 5 to the Public Services Reform Scotland Act 2010 to insert a reference to prison monitors in the wrong place. Secondly, paragraph 8(2)(a) and (b) in Part 1 of the schedule contains an error. The provision amends Schedule 1 to the Public Records Scotland Act 2011 to insert reference to lay monitors and prison monitors appointed under Section 7(3) of the Prisons Scotland Act 1989, when this should refer to Sections 7A1 and 7B1 of that Act. And thirdly, the consequential amendments in paragraphs 3(5) and 6 and 6(2) and 3 of Part 1 of the schedule, which amend provisions of the Criminal Justice and Public Order Act 1994 and the Crime and Punishment Scotland Act 1997, should be omitted. The Scottish Government has undertaken to correct the errors when the order is finally laid before Parliament. Does the committee agree to draw the draft order to the attention of the Parliament on the general reporting ground as it contains some drafting errors? And does the committee agree to note that the Scottish Government has undertaken to correct the errors before the order is finally laid before Parliament for approval? Yeah. And furthermore, the committee is invited to welcome that a comprehensive version of the proposed explanatory document has been relayed. The document now contains further details of how the Scottish Government considers that the draft order implements the various requirements of the Public Services Reform Scotland Act 2010. Does the committee agree to welcome this? Finally, on this instrument, The committee is invited to note that the draft order does not, in Article 1, propose a date when the provisions would come into force. This will be required in the order to be finally laid. Are we all agreed? Okay, thank you. Agenda item number 4 is consideration of instruments subject to affirmative procedure. No points have been raised by our legal advisers on the following instruments: the Health Board's Membership and Elections Scotland Order 2013 draft, nor the Freedom of Information Scotland Act 2002 Historical Periods Order 2013 draft, nor the Land Reform Scotland Act 2003 Modification Order 2013 draft. However, in relation to the Health Board's Membership and Elections Scotland Order 2013 draft, the committee may wish to note the lack of clarity provided by the explanatory note and policy note as regards the purpose and effect of Article 3 of that order. The article has significance in making provision for certain subsections of the Health Board's Membership and Elections Scotland Act 2009 to continue to have effect in the Fife and Dumfries and Galloway Health Board areas, despite the order revoking the pilot arrangements for Health Board elections in those areas. An explanation for Article 3 in the note would have been useful to readers and for scrutiny of the order. Do members have any comments? No? Okay. That aside, is the committee content with these instruments? Okay, thank you. We now move to agenda item 5, which is a consideration of instruments subject to negative procedure. Our legal advisers have raised some points in relation to the following instrument: Adoption Recognition of Overseas Adoptions Scotland Regulations 2013 SSI 2013-310. The policy intention of this instrument is that adoptions effected under the law of countries or territories which were not specified in the Adoption Designation of Overseas Adoptions Order 1973 and which are specified in the schedule to the instrument will only be recognised as overseas adoptions if they were effected there on or after the 3rd of January 2014. The instrument does not specify whether all adoptions effected under the law of such countries will be recognised from the 3rd of January 2014, regardless of when they were effected, or whether only those affected once the instrument is in force will be recognised. The Scottish Government accepts that, as currently drafted, the instrument does not make the policy intention clear, and in its response to the committee undertook to make an amendment to the instrument to clarify the policy prior to the instrument coming into force on the 3rd of January 2014. The instrument was laid on Friday and will be considered by the committee at a later date. Members may wish to comment separately on the broader issue of quality control which this matter raises, but first I propose that we deal with the narrower question of our scrutiny of the individual instrument. I will give members the opportunity to comment on the wider issues separately if they wish. So does the committee agree to draw this instrument to the attention of the Parliament under reporting ground H, as the meaning of the instrument could be clearer?
We also note that we welcome the commitment to the prompt corrective action that the government suggested they would do.
That's question 2.
Is it indeed?
Yeah. And does the committee wish to welcome the Scottish Government's prompt action to address this concern before instrument comes into force? Okay.
I'm sorry I was so premature. Just shows you're reading the papers.
Returning to the broader issue I mentioned, the committee has previously written to the Scottish Government about the supporting information which the Parliament requires to ensure proper scrutiny of instruments which involve the transition from one regime to another. It is important that the policy note makes clear how the Government will treat cases which occur prior to the change after that change takes place. In this case, further information was required from the Government to understand how existing adoptions from newly recognised countries would be dealt with in Scotland once the instrument came into force. The instrument could have been read in 2 different ways, which could result in confusion as to the status of such adoptions in Scotland. Do members have any questions or any comments? Yes, John.
Thank you, Convener. Given that mistakes have been made in the past, and that this committee, Parliament and Government have been criticised in this area in the past by the courts, I'm disappointed that there again appears to be a lack of quality control in the drafting of these instruments. And I would have thought that the Government would want to address this and must be disappointed that this inadequacy is appearing again. So, like Bruce Crawford, I very much welcome the government's intention to correct this problem, but given the criticism that we were subjected to in the past, I think we need to get on top of this problem.
Okay. Any other members? Thank you. Given that the further information was required in this case, do members agree to write to the Scottish Government, reminding it of its commitment to clear policy notes on such matters? Yes. And mindful of previous concerns raised by the committee, and given that a corrective instrument has been necessary in the context of transitional changes to the law of adoption, do members agree to seek further reassurance in writing from the Government about the adequacy of its quality control mechanisms for the drafting of instruments? Okay. No points have been raised by legal advisers on the flood risk management designated responsible authorities Scotland Order 2013, SSI 2013-314, nor the letter fixed penalties Scotland Order 2013, SSI 2013-315, nor the fundable bodies Scotland Order 2013, SSI 2013-319, nor Criminal Legal Aid Scotland Fees Amendment Regulations 2013, SSI 2013-320, nor the Seed Scotland Miscellaneous Amendments Regulations 2013, SSI 2013-326, nor the National Health Service Travelling Expenses and Remission of Charges Scotland No. 2 Amendment Regulations 2013, SSI 2013-327. With regard to the Criminal Legal Aid Scotland Fees Amendment Regulations 2013 SSI 2013-320, members will have seen the written submission from the Law Society of Scotland, which the committee has received in relation to this instrument. Do members have any comments on the submission?
No.
No.
Okay. And that aside, is the committee content with these instruments? Okay.
I would just say I'm particularly pleased to see that the tomato has now been properly renamed and Order 2013-326.
Okay. Thank you, John.
It's an historic day. Without a doubt.
On this historic day.
Okay, we'll now move on to agenda item number 6. This is the consideration of instruments not subject to any parliamentary procedure. No points have been raised by legal advisers on the Act of Sederant Rules of the Court of Session Amendment No. 7, Miscellaneous 2013, SSI 2013-317, nor the Pollution Prevention and Control Designation of Energy Efficiency Directive Scotland Order 2013, SSI 2013-321. Is the committee content with these instruments? Okay. And agenda item number 7. This is a consideration of the Scottish Government's response to the committee's Stage 1 report on the Marriage and Civil Partnership Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Do members have any comments? No. Okay. And are we content to note the response and, if necessary, reconsider the bill after stage 2? Yep. Agenda item number 8. This is consideration of the Scottish Government's response to the committee's stage 1 report on the Public Bodies Joint Working Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Do members have any comments? No. Are members content to note the response? Okay. And I'll complete the question and, if necessary, reconsider the bill after stage 2. Okay. Okay, thank you. And agenda item number 9 is the business of consideration of the Scottish Government's response to the committee's stage 1 report on the Children and Young People Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Do members have any comments? No? Okay. The committee will note from the Scottish Government response that it is considering giving the Scottish Ministers flexibility to extend Scotland's adoption register in future to allow it to cover other forms of permanent care planning for children in addition to adoption. If the Scottish Government concludes, however, that the register should be restricted to adoption, the committee may consider that the amendments should be brought forward at stage 2 to narrow the breadth of the power. Does the committee therefore agree to write to the Minister for Children and Young People, asking her to inform the committee of what the Scottish Government proposes once its consideration of the issue is complete, in order to allow the committee to form a view on whether its concerns in relation to this power have been addressed? Okay, thank you. That brings us to the end of the meeting. The date of our next meeting will be Tuesday, the 3rd of December, and I now close this meeting. Thank you.